The National Herald case is the ongoing case in a Delhi court filed by politician Subramanian Swamy against politicians Mrs. Sonia Gandhi and Mr. Rahul Gandhi, their companies and associated persons. As per the complaint filed in the court of the Metropolitan Magistrate, Associated Journals Limited (AJL) took an interest-free loan of 90.25 crores, that is about $11 million, from Indian National Congress, a political party. It is alleged that the loan was not repaid. A closely held company, Young Indian, was incorporated in November 2010 with a paid-up capital of 5 lakh rupees, and it acquired almost all the shareholding of the AJL, that is Associated Journals Limited, and all its properties also. The properties are supposed to be in excess of 5,000 crores in worth. That's $580 million. Swamy alleged criminal misappropriation by both Mrs. Sonia Gandhi and Rahul Gandhi. This case has been going on for a long time, and the opposition has been watching very closely to see that, when the parties who are defending are going to be behind bars. But let me tell you, when you carefully study this matter, there seems to be something very interesting about this. Let us see. Forget for a moment what the ED is saying, or the opposition is saying, or the people who are not too much favorably disposed towards the Congress party are saying. But here is something very interesting. That is, no personal enrichment has been proven so far. The Gandhis did not personally take any money from the transaction. Young Indian is registered as a Section 25. Now it's called Section 8 under the Companies Act, meant for non-profits and for non-profit purposes. The defense may argue, we didn't enrich ourselves. The assets remain within a not-for-profit entity aimed at reviving AJL and its newspapers. What is wrong with that? Party loan. Party loan was not given for any reason but to only assist the revival of AJL, because AJL has a history. AJL was started in 1937. So AJL published National Herald, and National Herald has a greater history. And so many freedom fighters were part of this mission of bringing out National Herald. So if the Congress party decided to assist the revival of National Herald newspaper or National Herald publication, what is wrong with that? So INC's 90.25 crore loan to AJL is presented as support to revive historically significant newspaper, not a business investment. That has to be taken as the primary point in this case. Congress has argued that no profit motive existed. Nobody was planning to make money out of this transaction. Of course, what led to this kind of loan to be given is a different case altogether, but that does not make it the most important point in this case. That could have been investigated as a different case altogether. See, here the point is, Congress has been saying it was a merely internal resource support for a party-aligned publication. It was not invested to make any profit for the defendants. The party's money was not used for some extraneous activity. It was only to revive a publication or the publishing house that has been aligned with the party historically. So that is a different case altogether. But does that merit ED intervention? I'm sure the opposition would also, perhaps the central government, could also bring in the Interpol too. That is its wont. But to use this to trouble Mrs. Gandhi and Mr. Rahul Gandhi is nothing but laughable. Legal transfer. Legal transfer is not fraud. Associated Journals Board approved the transfer. It was company level business decision, and no law bars a company from restructuring or transferring ownership. If all documentation, board resolutions, filings, ROC compliance are in order, it may be argued that the transaction was absolutely legitimate, even if it's politically controversial. Nobody expects the BJP to be completely, agreeing with this kind of a transaction. Of course, it can find things that are not perfect. BJP has not been having transactions or making transactions that are 100% perfect. You know about the PM cares. So only when Congress may have not done it the way the BJP would have expected it to be done, would have been mostly like, do more wrong perhaps, according to the BJP. But there is not that big wrong at all here. Then the next is Section 29A of RPA. May not apply at all here. Subramanian Swamy alleged violation of the Representation of the People Act. Section 29A. Since the political party gave funds for a commercial purpose. However, the purpose was not commercial per se. It was to revive a press house with historic and ideological affiliation with the Congress. The defense certainly would say there was no trade, business or profit, hence no RPA violation. Income from properties may be lawful. Some properties being rented out may have legal usage permissions or lease modifications post AGL restructuring. There's nothing wrong in it. That is to ensure that the publication is self-funded, is sustainable. So that is not illegal at all. But that could be questioned in a court of law. But does that warrant arrest? Does that warrant putting the leaders behind bars? Does that warrant the kind of defamation that is being unleashed? If permissions were properly granted or regularized, there is no illegal usage, just reallocation or underutilized space. So, there is also a question about, what the premises or what the lands have been used for. But that is a question not about criminality. It could be about misjudgment at best. So, are you saying that, all these things can be only construed as Mrs. Gandhi and her son conspiring to profit from it? Do you have any proof in that? No. Non-active publications does not invalidate ownership. The publication was dormant, but AJL was not defunct. AJL was there. A lot of people even said, perhaps, their opinions were not considered totally, people who were like shareholders, but it was not a listed company. See, the takeover was aimed at revival, a good purpose. Perhaps that is what the court has to take into consideration. The decision to restart National Herald in 2016 proves the intent. Nobody said, we are going to acquire National Herald and the AJL's properties and we would make it into something else, or maybe a Disneyland or something of that sort. Statute of limitations and delays. Many events in question took place in 2010, 2011. Defense certainly has a case in here saying the limitation issues are challenged, why action was delayed until 2012 or later. Procedural lapses by complainant or investigators. Subramanian Swamy's case is based on private complaint, not government action. That should be thought about. Defense would certainly talk about procedural flaws or question ED's basis for invoking PMLA, especially if they can prove no proceeds of crime. ED has a definite purpose. It can't just speculate. It can't just get into things just because it wants to put somebody in trouble. It can't just get into something because there could be some defamatory air that is brewed. What are the other potential arguments that could be in favor of the defendants? That is Mrs. Gandhi and Mr. Rahul Gandhi. What about the minority shareholder rights? Certainly, Minority shareholder rights weren't violated if due process was followed. Like what Mr. Kachu and others claim. AJL was not a publicly listed company, so takeover regulations under SEBI or public listing don't apply at all. Allegations of sham intent are speculative. It is somebody's imagination, somebody's vile, intent. That doesn't mean that there is anything like that. It is just an allegation. Unless criminal intent is proven beyond reasonable doubt. And there is nothing here. It has been investigated. Properties have been attached. And you've caused enough distress to the defendants already. What more do you want? What really helps the defendants, that is Mrs. Gandhi and Mr. Rahul Gandhi? And the party itself, the Congress party, there is no direct financial benefit that's been established. Structuring, you can imagine things. You can concoct things. You can say that there is a possibility of this and this looks like this and so on. Things have not been established in a court of law. Of course you investigate. That is your desire. And the Congress party has never stopped you from, investigating. Never stopped you from, finding the kind of things that you want to find, if there are things like that. But here, there is nothing. Structuring within the legal bounds of the Companies Act. And Section 25 company then allowed this to happen. And if there was any irregularity, it is at the most a corporate misdemeanor. That is all. Positioning of Young Indian as a revival vehicle is not a profit-driven purpose. The National Herald case appears to rest more on the political optics of impropriety than on undeniable evidence of criminality. It is just that it's good for the opposition to talk about it, to malign Mrs. Gandhi, to malign Mr. Rahul Gandhi. It's nothing to do with, whether something wrong was done or not. It is just, it's an opportunity for the people opposing the Congress party to just find as much fodder, imaginary fodder as possible with their own imagination, hallucination and suppositions to malign. And that's all the purpose that is here. Hate politics. The ED's case feels hypothetical unless it proves proceeds of crime. Just because the ED is involved doesn't mean that something is criminal. And that is the way the current central government has been playing the optics. So the moment ED is brought in, the ordinary person will start thinking that, of course, it looks like there is something that's bad. And that itself is enough for a certain political party to earn its political capital out of this. The ED's domain is money laundering. But here, they must prove that income or assets were laundered, gained from a scheduled offense. Merely acquiring assets through a legally incorporated not-for-profit does not automatically constitute laundering unless there is clear criminal origin of funds, clear intent to disguise or convert illicit gains. There is no public evidence that Mrs. Sonia Gandhi or Mr. Rahul Gandhi personally profited or converted the assets into private wealth. Not even a figment of truth in the opposition's canard. Most allegations are based on motive only, not proof. Isn't that enough for anybody to understand this case? Mr. Swami's core claim is about intent. That Young Indian was a sham to usurp assets. But establishing intent to defraud in court requires direct evidence, criminal mind, not just structural moves that appear suspicious. That way, literally everybody can be put behind bars, just on the basis of, harassing somebody with just the proposition of intent. The defense's paper trail looks very, very strong here. If the resolutions, ROC filing, shareholder approvals, perhaps, discounting some of the objections are in place, the defense has a credible legal structure. But in no transaction, everything is 100% perfect. But that's the way things are. So if there are such discrepancies, look into them. You could put in a penalty, but you can't make that criminal intent or profiting from misdeeds. Courts are likely, in this case, distinguish between poor optics and actual criminality, unless there is proven misrepresentation, concealment, or coercion. None of these happened. Nobody has complained. Nobody said Mrs. Gandhi went and, forced somebody to do something, scared somebody, or something like that. At most, this may be a corporate governance or ethical issue. I won't say that. But if at all anybody has, in a democracy, we can't stop people from finding fault. But finding fault is different from wanting somebody to be troubled, wanting somebody to be put behind bars because they are your political opponents. These two are different things. So if you think there is political advantage, spell it out. But a corporate misdemeanor at best, if at all you want to call it that, and that is a different case altogether, and making it a criminal case are two different things. The loan from Congress party to AJL could be seen as a misuse of political funds, but it's not criminal on its face unless it violated specific provisions like tax evasion or party funding restrictions and so on. The Congress party is bold enough and straightforward enough to answer these questions. Even if procedural lapses occurred, failure to notify certain shareholders, like the way some of them are alleging, those are civil or regulatory issues, not criminal misappropriation. This all boils down to one thing. This case, stripped of political content, does only amount to no more than a questionable restructuring, not an open and shut criminal conspiracy. Unless the ED unearths clear evidence of siphoning, layering, or unlawful gain, which I'm sure, like in most of the other cases, ED has not been able to do, it risks being viewed as overreach by this agency based on some motivation. While the political nature of the parties involved gives this case dramatic overtones, from a purely legal and forensic perspective, especially around the structure, lack of personal benefit and statutory compliance, this has some substance to prove that this is only a political case intended to harass Mrs. Gandhi and Mr. Rahul Gandhi, the Congress party, and the others associated. Otherwise, this is just a hypothetical or inferential case. Thank you.